Punishment is to be assessed at 6 years in the prison. The state is silent on your application, and there's restitution to be determined. And of course, outside the agreement, there's no contact with certain persons. All right, our court is calling 2024 CR 012163, State versus Jeffrey Guerrero. Can I have parties announced for the record? State.
Andrew Harrison.
Defense.
Scott Sullivan from Mr. Guerrero, Your Honor.
And are you Mr. Guerrero?
Yes, ma'am.
All right. You entered a plea on May 22nd. You waived PSI and TAP evaluation. According to the plea bargaining agreement, punishment is to be assessed at 6 years in the prison. The state is silent on your application, and there's restitution to be determined. And of course, outside the agreement, there's no contact with certain persons. All right. Are parties ready to proceed?
I am, Your Honor.
All right, counsel, do you have any witnesses?
No, Your Honor.
All right, the court will hear your argument.
Yes, thank you, Your Honor. Mr. Guerrero is an excellent candidate for deferred adjudication. It will allow the court to, and he'll have to be mindful that any mistake could cost him a lot of prison time. So I think with that over his head, I think he wants to comply with the conditions that this court lays on him. And I think he will do them diligently, Your Honor. And I just think it's the perfect fitness for him. Thank you, Your Honor.
All right, Mr. Guerrero, I don't think that probation is appropriate for you. According to the stipulations, this fire was set because you were paid. That's what you told the police.
I didn't tell the police that. It was somebody else who told the police that. That was the other people that told the police that. And at that, there was no damage and nobody pressing charges on.
No, I mean, you started, it says here that you attempted or you started a fire, so that's an arson, and you did it at an apartment complex. Many other people could have been injured.
It was a fence, man.
Okay. All right. Is there anything else?
And
Oh, do you want to testify?
because the video that I had
Would
saw,
you like to testify?
what does that mean?
That I take, have you raise your right hand, swear you in, and you tell me your story. All right, do solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Jeffrey Guerrero.
All right, so Mr. Guerrero, I want to let you know that if you tell me your story and the state deems that it is untruthful, then even though they do have, even though they made the agreement to remain silent, if there's something that you're untruthful about, they can question you about that. Do you understand? All right, what would you like to say?
I was just saying that
Everyone, please whisper.
from the cause of it, I mean, when I saw the videos, what he showed me, they didn't have no proof of who even did it or what, and then they're pointing the finger at me, and they saw a vehicle, and then from a vehicle, just because it was my ex, they know where I live, they've seen what I do, they see what I do every day, you know, they pass by the house every day, so they're pointing the finger at me because we're stealing my stuff, and they were just trying to get me in trouble for anything, but I haven't associated with these people like in 30 years, and they want to point the finger at me. And from the scene, when I saw the video, they were towing a truck, and you can't even see the license plates. From the license plates, they went to another place. Just by word of mouth, they told them where I live, so they went to my house and ran a plate there at my house, and they came under my name. That's what they told me, and that's how they got proof of saying that that truck was mine. If they didn't read, how could they say it's my truck if they can't read the plates of the apartments?
All right. Any questions?
And
No, Judge.
from the looks of it, there was no damage done to any of the when I saw the videos.
All right. Anything, any
Nothing
questions?
for me,
Jennifer?
Your Honor.
All right. This is what the court is going to do. The court is going to find you guilty. The court is going to sentence you to 6 years in the prison, give you credit for any time served. There's a $2,000 fine, time and money to run concurrent. There's to be restitution, if any, to River Trail Apartments and Orlinda Galvan. There's to be no contact with Orlinda Galvan, Jose Galvan, Sandy Galvan, the River Trail Apartments. All right, did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yeah.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you, sir. All right, Perry Carrill. Hello. Good morning. Morning, John. Hi. How are you doing?
I'm good. I'm good. I'm actually a little scared, but I'm pretty.
Oh, I hope you're not scared about being here because everyone here wants you to be successful. I want you to be successful.
I believe.
So I'm just trying to get information from probation about how you're doing
Yes.
and see whether or not your probation should be ended. So I'm just going to take a report from them.
Okay.
Yes.
Judge, there was an extension status report sent into the court for him to be extended a year on his probation. The main reason for the extension is for him to be able to pay his restitution.
Mhm.
There was otherwise, he's been doing good on probation. We don't have any concerns. The original amount of the restitution was $14,000. He's paid to date $5,238, leaving an $8,762 balance. I spoke with Mr. Grillo. He says he has a plan that he wanted to tell the court, and hopefully it will be acceptable.
All right. So what's your plan?
I found it's taken this long to finally put together in a position with a felony, even though I haven't been convicted, it's still a very good task, especially at my age.
Yeah.
So with the construction jobs, I get chased off of because I'm just not as young as I used to be.
Yeah.
And it's just taken this long to finally find a job with that on my record, despite that, to earn enough to pay the restitution. And not only that, but I have to take care of my mother. She's 80 years old now, and she has to retire. I mean, she doesn't really have a choice.
Yeah.
So, and that's a good thing that I'm here. So I've done the best I can. When I went to jail, that was the best thing that ever happened. I made up my mind there that I was never going to fall that low. I was raised better. So there's a lot of pride. And my family was important. So
All
I
right.
can do it.
All right, so what I'm trying to do is, because there are some cases where everybody has done everything, and I'm like, yeah, there's no need to keep them on. But the reason why your case is extended is because of the restitution. So if you were to pay all of your restitution, then you'll be done today. But
I'm not trying to avoid it.
yeah, but I know you have a plan. I don't understand why the restitution was so high to begin with. This case wasn't before me when it was from
It
216.
was a Hill big with it. I was on the bench back then, I
Mhm.
believe. So
So, I mean, is this appropriate restitution? I mean, I don't understand. I read the report, I read the stipulations. And the stipulation there was, I mean, where is the restitution coming from? And who is the restitution going to?
A person, an individual that
I'm assuming a restitution was held. Yeah.
hospital bill and for the ambulance.
Okay. And we actually received documentation for that?
That get by. I don't. see-
All right, so what's in the PSI, and I don't like to go behind other people's rulings, but what's in the PSI? Is there any documentation or is it just somebody just said, this is how much I'm due? Because if not, counsel, that may be something that you can look into.
Yes, Judge. I agree. I believe it needs to be substantiated. So, no, Mr. Carrillo appreciates us looking into it to see if that was justified, just to verify. I understand that. Look into possible.
That's what I hear, but I've never seen anything.
There's nothing attached to the PSI for the documentation for that. It's just based on the victim's statement.
All right, so then this is what we're going to do, unless there's objections. Mr. Gerhand?
Yes, sir.
On this case was done before I was on the bench. It's from 2016. There was restitution that was ordered. It wasn't included in the stipulation. But in the PSI report, they came up with a restitution amount of $18,000. But there's no documentation for that. That's just somebody saying I'm owed $18,000. But no documentation was submitted. So unless there's an objection, because it's really outside my jurisdiction at this late date, but I don't think it's fair for someone to pay restitution if there was no documentation. And it doesn't appear that it was done with his attorney being present, because it wasn't in the stipulations. And then when I read the previous judge orders, well, actually, there's nothing here, but it doesn't appear that at the time of sentencing, that a restitution amount was given. It appears that just in the stipulations, it's in the stipulations. So therefore, this is the amount of restitution.
Judge, I did.
Okay.
Well, Judge, the way I'm reading this is this a $18,088, but it says the actual restitution is 8,000.
So the restitution amount was originally for the bills, I believe, was 14,000.
Yeah.
And then 5,000 has been paid, and then there's a remaining balance of 8,000.
So actually restitution was only 14,000
14,000.
to an individual, because the
Yeah.
other ones are fees and everything.
Yes.
I mean,
So-
go ahead. I'm sorry, Judge.
And so I'm thinking, if there's no objection, I don't think the defense would have any objections. If somebody can look into and see, if there's some documentation for this other than somebody just saying, this is what I owe. I mean, this is what is owed.
I guess what the state's position would be, Judge, since, don't want to victimize a victim again,
Mhm.
that we would, one, ask, if we do have documentation, two, that we reach out to the actual victim
Yes.
and see if they've been made whole from this. Since it is an aggravated assault with a deadly weapon.
Okay. All right, if we can do that, because it appears that there was some mental health issues from what I read in the stipulations. So there were some major mental health issues going on at the time. So then if y'all can look in that, for now, the extension is going to be granted. And then if defense, you come in with information, or probation, if you have information that there's actually no more restitution owed, then the court will strongly consider just terminating because he's done everything.
I think Mr. Garrett had obviously the good idea of reaching out to the complaining witness just to verify that the amount reflected here was the actual amount, and then obviously documentation, and to see what their feelings are as to more amount need to be paid, or if they've been made whole, like Mr. Garrett has said. So I can have my investigator also try to reach out to the complaining witness as well. I know the state will make efforts too, so we can hopefully reconvene and hash this out as to what perhaps needs to be owed.
My only fear is, this is coming up on 10 years old.
Oh, yeah.
And victim, may have not kept documentation if it hadn't been turned over. So that's one of my concerns.
All right.
Maybe we can, yeah, we can confer, work it out, see what she would be wanting, something less than 8,000 or if she wanted 8,000.
All right, so it'll be extended, and then whenever y'all want to put it back on the docket, it can come back on the docket.
Okay, good.
And extended for a year? Okay. All right, thank you. Right. All right, first thing on this case, where are we on discovery?
Judge, I've gone ahead and looked at what's in the state's file. I need to go through the reports to make sure all the videos match. So it's our first setting. I would ask for one more setting.
All right, Ms. Ferguson, on this case, I need a 30-day setting for discovery.
But Judge, we have conferred, the state's reached out to the complainant. We're talking about an offer. There was an offer already, so.
Okay.
we're moving.
All right, July 10th is going to be your discovery date. And I also have a motion to modify conditions of bond.
Judge, we do need to get a setting for that at some point.
All right, are you all ready to proceed on this motion to modify bond conditions? They're asking that the GPS be removed.
Sure. I mean, if defense would like to proceed today, or if they want to reset it, it's up to the court.
We haven't conferred on that, so I can do that. I don't think there'll be an agreement. So I don't know that we're in a position.
All right, so he says that he wants it removed because of employment. Are you all able to agree to partial GPS for employment?
The state would agree to partial for employment purposes.
I'm on partial. I'm
All
on
right.
partial.
He's on partial
I
right now.
agree.
So there is his ability to work outside those hours, of course, is affected. And so we'd ask for, tracking only. This case has been pending a while. It was just indicted. We haven't had any issues with his compliance with GPS.
Mhm.
There were some issues with drug counseling, but we got that resolved.
All right, state, I don't know how you would feel about tracking. I don't know if you're ready to proceed on it, if they're just asking for tracking only.
Just since it's spur of the moment, we would be opposed to it, Judge. The indictment and prior history purposes.
All right, so let's do this. If there's an issue with your employment, all you have to do is let the court know. The pretrial services officer, have there been any issues? Oh, and I'm sorry, state your excuse.
Thank you, Judge.
With the pretrial services officer, has there been any
Um,
issues with your working?
Mr. McCory's been pretty lenient, but due to the, I guess, overcrowding or understaffing,
Mhm.
sometimes he doesn't get it. So because of these court issues, I haven't been able to do overtime, things like that because of the GPS.
Mhm.
I'm not looking to make a bad situation worse. I'm more than confident that it will go. But
And just those are the issues. We haven't had any issues with the complainant. There haven't been any contact issues. Certainly, there's been nothing along those lines.
So has pretrial services, have they told you to let them know within 24 hours if your work
Yes.
schedule? Okay, well, there shouldn't be any problem with the work schedule. What I can tell you is anytime there is, and your attorney will tell you this, anytime there is a pretrial services violation, some type of violation, the first thing I do is I ask the pretrial services person, hey, are they back in compliance now? Because sometimes there's miscommunication. And then if they say, yes, they're still not in compliance, I'll usually have a hearing. I don't just knee-jerk reaction sign things. All right? But whenever you want that set, just let the court know. All right, thank you.
thank you. You have a
The case of State versus Jeffrey Bueno Guerrero began like many plea hearings, calm and procedural. Judge Stephanie Boyd reviewed the record, confirming that Guerrero had already entered a plea and waived key evaluations. The agreement on the table was serious: 6 years in prison for a felony offense involving arson, with restitution still to be determined. Despite this, the defense pushed for deferred adjudication, arguing that Guerrero could succeed on probation. Judge Boyd wasn't convinced. She pointed directly to the stipulations in the case, noting that the fire was allegedly set because the defendant was paid. That's when everything changed. Guerrero interrupted, denying that he ever told police such a thing. Instead of ignoring the comment, Judge Boyd did something decisive. She gave him the floor and offered him the chance to testify under oath. Sworn in, the defendant claimed there was no proof and suggested he was being targeted unfairly. His statements did little to sway the court. The prosecution had no questions, and Judge Boyd was ready to rule. With clear authority, she announced her decision: guilty. The sentence followed swiftly. 6 years in prison, credit for time served, a $2,000 fine, and restitution to the affected parties. Judge Boyd also imposed strict no-contact orders and explained the long-term consequences of a felony conviction, including the loss of firearm rights and the inability to appeal due to the plea agreement. There was no shouting, no theatrics, just firm justice. Judge Stephanie Boyd closed the case with a brief but powerful send-off, reminding everyone in the courtroom that accountability matters. In a matter of minutes, hope for probation turned into a hard prison reality, proving once again that Judge Boyd does not hesitate when the facts demand consequences.